Hello friends, in the series on the income tax cases, today we will discuss a very important issue on the rulings which are given by the authority for advance ruling. The issue arises in this case is that whether the ruling given in case of B Assessee can be applied in the case of A Assessee, and the second issue was that whether the ruling given in case of B Assessee can be taken as a basis for reopening the case of the assessee who is not covered by that ruling. This matter has been decided by Bombay High Court in the case of Mrs. Usha Eswar versus Income Tax Officer and others. This case has been reported in 470 ITR at page number 200. The matter has been decided by Honorable Bombay High Court and the date of the judgment is 7th July 2023. In the present case, assessee is a non-resident. The assessee has applied before the authority for advance ruling on three issues. The first issue was that whether the capital gain on the transfer of movable assets in India is taxable, and the second issue was regarding the taxability of dividend and interest. When this application came before the authority for advance ruling, the authority for advance ruling, after pursual of the provisions of the Income Tax Act and Article 4, Article 10, Article 13, gave the decision that in the case of the assessee is a resident of United Arab Emirates within the meaning of Article 4 of the Double Taxation Avoidance Agreement, and the capital gain arising from the transfer of movable assets is exempt according to Article 13 sub-Article 3. At the same time, authority for advance ruling said that the dividend is taxable at the rate of 15% and the interest is taxable at the rate of 12.5%. After some time, the income tax officer of the assessee issued notice to the assessee under section 148 for 4 assessment years on the basis of ruling given by the authority for advance ruling in some another assessee by recording the reasons that the benefit of double taxation avoidance agreement was given wrongly to the assessee. The assessee went to the Bombay High Court. When the Bombay High Court heard the matter, the Bombay High Court gave its verdict by saying that the authority for advance ruling is binding only on that assessee who has sought the ruling before the authority for advance ruling, and it is binding only for those transactions for which the ruling has been sought by the assessee. Bombay High Court further said that the ruling given by the AAR is binding on the authority, is binding on the assessee, Commissioner of Income Tax and the lower authorities before the Commissioner. Bombay High Court also said that this ruling cannot be disturbed until and unless there is change in law with retrospective effect or there is change in some facts. As far as the reopening on the basis of ruling given by authority in the case of some other assessee, the Bombay High Court said that it is not lawful that the case of the assessees are reopened on the basis of ruling given by the authority for advance ruling in some other assessee, because if it will be done, then there will be no benefit and there will be no logic of seeking these rulings from the authority for advance ruling, and there will be no certainty for these rulings. Friends, this case is very important as far as rulings are concerned which are given by the authority for advance ruling. It suggests a very clear message that the case of an assessee cannot be reopened on the basis of ruling given by the authority in some other assessee, and they are binding on the assessee, authority, commissioner and all the authorities below the commissioner. At the end of this video, once again I am repeating the name of the case. The name of the case is Mrs. Usha, Eswar versus Income Tax Officer and others, and this case has been reported in 470 ITR at page number 200. The matter has been decided by Honorable Bombay High Court and the date of the judgment is 7th July 2023. Thank you, friends.